Good morning, Ms. Allen. Mr. Fleming. You may proceed.
May it please this honorable court. My name is John Fleming. I represent the plaintiff, Michael Boyd, administrator of the estate of Kelly Boyd. This matter is before this court upon review of the granting of the lower court of a motion for summary judgment, and arises out of the following facts. On or about June 24, 1998, Kelly Boyd, age 15, was riding her bicycle on a public way in the town of Abington, Pine Street. She also lived on Pine Street in Abington. As she approached a railroad grade crossing, the gates were down, and as she approached the crossing, she stopped. A train, this was a two-track section of the old Colony line, and as she approached the grade crossing, a southbound train went through the grade crossing. After it went through the entire grade crossing, Kelly looked a little bit to one side and then started to go into the grade crossing and was struck almost immediately by a train coming in the inbound direction, the other track. The plaintiff initially brought this action alleging that the MBTA and the National Rail Passenger Corporation, also known as Amtrak, was negligent with respect to this incident. At some point, the defendants moved for summary judgment on the grounds that reckless and willful conduct was the required standard of proof in the case, and the plaintiff then amended his complaint to include such a claim. The basic allegations in this case relating to reckless and wanton conduct are that the train engineer in this particular case, as he approached this intersection, was traveling for a period of time of approximately 17 seconds at a speed in excess of 80 miles an hour. There was evidence before the lower court that the train may have been proceeding at a speed of between 81 and 92 miles an hour. In addition, there were two state statutes in existence at the time. General Laws, Chapter 160, Section 138, which required that a continuous warning horn be sounded by a train approaching a public grade crossing starting 1,320 feet prior to the actual crossing. There's also another statute, Chapter 90, Section 15, which requires that a warning horn be sounded starting at a distance of 1,500 feet.
Is there something that tells them they're that distance away? Is there like a device on the tracks that, signals now's the time to blow your horn or something like that? Or how do they figure out 1,300 feet or 1,500 feet is a split second if a train's going that fast?
I believe that under Amtrak regulations there's supposed to be something that's posted on the track.
What about this is a state law. How do they know they're a quarter mile away from the intersection?
Well, for example, in this particular case, there's another grade crossing that's a little bit more than a quarter of a mile away from this grade crossing, which would certainly give the train engineer knowledge. So
they don't know. There is no device that alerts them. What happens when they were approaching the other grade crossing that was when they got to a quarter of a mile from the previous grade crossing? How would they know when to sound the alarm, sound the horn?
Well, it appears that the warning was given at prior grade crossings, but wasn't given at this particular grade crossing.
Well, in any event, the record doesn't really tell us, I guess.
The record doesn't tell us because the witnesses who were deposed couldn't tell us exactly how Amtrak had this set up.
Okay. I was just curious. I don't think anything turns on that.
Was there any other evidence that would support the concept of recklessness?
Well, in this particular case, we believe that the concept of recklessness has to be viewed, the evidence has to be viewed in its entirety, and the important facts are as follows, Your Honor. This is the new Old Colony line, which was reopened as a commuter line in September of 1997 after it had been dormant for 30 years. There had been no high-speed commuter traffic on this railroad for about 30 years. And when the MBTA decided that they were going to reopen commuter traffic, they knew that they had a serious education problem because people were completely unaccustomed to having high-speed trains running on these tracks. And they knew that they were going to have to engage in a big public education program. And they also, when they set up the line, they put two tracks running through the part of the line in the town of Abington that had the highest concentration of public grade crossings. And it's commonly understood, and the MBTA has admitted, that grade crossings are the most dangerous location on an entire train line. And that's where there's the greatest likelihood of there being an accident. So what the MBTA did was, so that they could have a quote-unquote attractive schedule for commuters, they put the two sides of the two tracks in the area with the highest concentration of public grade crossings, and then they scheduled the trains so that they would meet and pass right in the area of these public grade crossings during the middle of the day.
Can I interrupt you again?
Sure.
What theory of recklessness was this brought on? The traditional one, which the appeals court quotes, in the face of a known or obvious risk, one intentionally persists in conduct involving a high degree of probability that substantial harm will result to another, and they're quoting from the Gage case and the Desmond case. Is that the theory you were operating on?
I think the theory that we're operating under is the theory set forth in the Sandler versus Commonwealth, which is that in this particular case there was a reckless failure to act because there was conduct which involved an intentional or unreasonable disregard by the defendants of a risk that presents a high degree of probability that substantial harm will occur.
That's kind of the same thing, just stated a little bit differently.
Correct.
So that was the theory, and that was the only theory of recklessness.
Correct.
Okay.
Could I ask you, with regard to this requirement of sounding a horn, not all grade crossings are equipped with the precise kind of gates and lights and whistles and stuff that this grade crossing is equipped with. Is that correct?
In other parts of the country, there are grade crossings that don't have gates. Around here, most crossings do have gates.
Is there evidence in the record of that, Mr. Fleming?
That
In Massachusetts, that most grade crossings have gates.
It's unclear to me whether that's actually documented in the record.
As I understand the defendant's position here, part of what the defendant is saying is that if you look at the total circumstances of what this person knew as the train is approaching, is that he knew and could rely on the idea that there were gates down and flashing lights and whistles sounding or something there at the crossing, and that his horn was therefore nowhere near the only warning, but an additional warning on top of others that would already be at the site. And that seems to be in part what they're relying on to say, to take this out of the category of reckless, that he knew about these other conditions that would have, reasonably, be viewed as diminishing the risk of harm. What's wrong with that?
I understand that that's their position. I think what's wrong with that is that the defendants in this particular case, the MBTA and Amtrak, there's support in the record, that they understood that when you put two tracks through public grade crossings, and you put, even if you have gates, pedestrians, bicyclists, people who approach the grade crossing do not understand that there can be more than one train that's going to be going through the crossing, and that there is a risk that people who are there, who see a train go through a crossing with the gates down, say, just as Kelly apparently did, that train has gone through the crossing, now it's safe for me to go across. And that's a risk that they understand. And the point that we've tried to emphasize, and again I would like to try to emphasize, is that the language in the case law that talks about the high degree of probability of substantial harm or death is what happens, what is the risk that's involved in this particular case. And the fact of the matter is that when you operate commuter trains at 70 to 90 miles per hour through through residential communities, if there's contact between that train and a pedestrian or a person on a bicycle or someone in a car, someone is going to die.
Well, that's clear. That's clear,
Yeah.
but that's one half of it. The other is a sort of a high degree of probability, and acting in spite of that in a reckless way.
Well,
Where's the high degree of probability here?
the high degree of probability, and the best example I can give you, because we've researched this, if you look at the draft comments that are set forth in the draft of the Restatement 3 dealing with basic principles of tort law, and they talk about reckless conduct and try to sort through how this actually should be defined. They talk about what shouldn't be dispositive, and what shouldn't be dispositive under, I think it's comment E, is the fact that something is not more likely than not to happen. You have to also consider the gravity of the harm. And the example that they give, and I would give this Court, is if an airline discovers, as they're getting ready to let a plane take off from an airport, discovers that there's a part that needs to be replaced on the plane. And if it fails during the flight, the plane very well could crash and 250 people could die. Now, if there's only a 10% chance that plane is going to crash if the part isn't replaced, it doesn't mean that the airline is not reckless, because the risk is that the plane is going to crash because of the failure of the part. The high degree of probability is that everybody on the plane is going to die if that plane crashes. And so you can't just focus on whether it's more likely than not that someone was going to be on the track at that particular time.
If we accept that, I mean, and I think the same point is made in the case to follow yours, that yes, trains are big things and they travel at high speed. Obviously, if they hit something, terrible things or someone, terrible things are going to happen. We all know that. If that's all it takes, then any deviation from any standard affecting the safe operation of trains, even just one, under your view, is automatically recklessness. There's not going to be any such thing as a negligent train accident anymore. They're all going to be elevated to recklessness because any inadvertence, violation of this, anything, you're saying when you're dealing with an instrumentality this dangerous, raises a risk of death. I mean, what's left that would qualify as negligent operation of a train?
Well, I actually, in this particular case, if all we had was excessive speed, I don't think we would be here asserting that.
Why not? Under your theory, because someone could be there. If you're going too fast, you're not going to be able to stop in time?
Because the risk in this particular case, what we say the risk in this particular case is that there will be someone on the track who does not appreciate that a train is coming. And what goes to that issue, the risk, what causes that to happen is the failure to sound a horn. It's a warning horn. It's the most important safety measure that a train has, or safety device that a train has as it approaches a public grade crossing.
Does the state law require, does any law require a drop gate when a train crosses a grade crossing?
There's a requirement that there be warning devices under state law, and then there's very extensive federal regulations that deal with what has to be done.
Does the record indicate at what distance from the grade crossing the train is when the drop gate goes down, or whatever that gate is called?
I do not remember that is specified in the record.
Mr. Fleming, I take it that your answer to Justice Sossman was the train was violating the applicable speed. It was going very fast, correct?
Correct.
That it failed to blow its horn, correct?
Correct.
That the railroad had deliberately scheduled through a busy area that there would be trains passing each other at the same time, which you would argue to the jury should not have been done, and you would produce presumably expert evidence to that effect. That the railroad made no effort to reduce the danger by educating children. Is that what you're talking about? I take it when you said the MBTA knew they had a big, that this was a dormant railroad, that they knew that they had to do some education. They did no education?
Well, we assert that the record shows that it was inadequate and that it had failed.
And failed to educate people about what?
About the fact, for example, that two trains could be going through crossings in the towns on this reopened line, and that when
there's tracks going in both directions, you need to be educated that trains could go in both directions, and that therefore they're going to pass each other at some time.
Grammar school kids, junior high school kids, yes, and I mean there was. This evidence has been, according to the ruling of the appeals court and the lower court, is totally inadmissible. of course, but there are surveillance, there was actual evidence from surveillance cameras that showed that kids were going around these gates, and that kids, after one train would go through, would then start going around the gate before another train came, and it was actually documented on camera. It's been deemed inadmissible because there's a federal privilege statute that says that evidence...
How long after this line opened did this accident occur?
The line opened in approximately September of 1997. After the school year had started, the accident happened on June 24, 1998, approximately a couple of weeks after the school year had ended.
Thank you, Mr. Fleming. Your time is up.
Thank you very much.
Mr. Mitzler?
May it please the Court, David Mitro on behalf of the defendants in appellees. I'd like to start by picking up on a point that Justice Cordy made earlier with respect to the probability of the risk in this case. For Kelly Boyd to be on the tracks, she had to violate state law to be present there. And so when you're evaluating the degree of the conduct or the acts or omissions of the train crew in this case, it's important to consider that the probability of Kelly Boyd being on the tracks at the Pine Street crossing on June 24th, 1998, required her to have violated the law to be there.
Well, that's just violating the law.
Mr. Mietzler, isn't that an argument that you make to the jury? We hear on summary judgment, and the question is, as a matter of law, can we conclude that this cannot go to trial?
Well, it's important to consider again, the plaintiff has urged a consideration of the totality of the circumstances.
No, I understand that, and those would be perfectly, if correct, would be perfectly permissible to draw to the attention of the trial effect, judge or jury. But here, it seems to me that we are faced with a situation of summary judgment, saying there's no conceivable set of facts in which any reasonable juror could find the defendants reckless.
The defendants have argued that a component of recklessness is knowledge of a risk. And it's the defendant's position that the risk that we're talking about is not a general risk that...
Knowledge by whom?
Knowledge by the train crew of a risk, a pending risk. And it's knowledge of that pending risk and the voluntary choice to either fail to alter your conduct or to act in a way...
Excuse me, when you say the train crew, you're talking about the particular train driver?
Yes, the engineer whose actions are at issue in this case.
So in other words, if the driver had received a radio call ahead saying, look, there are folks on the tracks up ahead, but had failed to slow down or take any measures, that might qualify.
And it was precisely that issue in the Gage case, which the appeals court ruled the element of knowledge of the train crew that there were individuals had been spotted on the tracks 3/4 of a mile ahead, and then the train crew or the engineers failure, armed with that knowledge, to either slow down or stop the train or take some action to avoid that pending risk, that permits a finding that someone acting in that circumstance did so with the level of conduct that we're talking about, not negligence, but recklessness.
Mr. Mietzler, one of the things that concerns me here, and I'm looking just at the language of the restatement, which we've, accepted for these purposes, there are two different theories. The first is the one you've just outlined. The actor, in this case the train driver, knows or has reason to know facts. Just as Cordy's hypothetical, you get a call, be careful, there are sheep crossing the tracks or there are people on the tracks. But there's a second theory that the actor does not realize or appreciate the high degree of risk involved, although a reasonable man in his position would do so.
And respectfully, I think that fits in precisely with what I started my argument with, is that it's not a reasonable person in the position of the train crew operator, the engineer in this case, shouldn't expect that someone is going to be violating the law and be on the tracks at that location at that time. So,
why not?
Why not?
Because the statute has that built right in. If somebody is illegally on the tracks, they have to show recklessness. So there's an assumption that somebody is on the tracks when applying this particular standard of care.
When you're looking at the nature of the conduct, you need to have that level of knowledge to impute to the...
Did the Gage case, that was not a grade crossing, was it?
No, it was not.
Okay.
It's a Sandler case, right?
Yes.
Sandler case, yeah.
Here we have a grade crossing. and we know that people cross tracks at grade crossings, or at least we know they do. They're entitled to do it lawfully. Sometimes they're not entitled to do it lawfully. And when trains are approaching grade crossings, they are required to sound their horn a quarter of a mile away from the grade crossing, and that wasn't done here.
That's true. And
he's a train driver, right?
Yes.
So certainly a reasonable person in those circumstances would know at minimum what you should be doing is sounding your horn, and you should certainly be sounding your horn if you're going way over the speed limit.
Well, in the first instance, it was 12 miles an hour over the speed limit.
If he had sounded the horn a quarter of a mile away from the grade crossing, anybody on the grade crossing would have had, I did the calculation, it's a really easy one to do, 11 and a quarter seconds.
The important thing about the circumstances at the grade crossing on this particular date and time is at the point in time that the plaintiffs are arguing the defendants should have been sounding the horn, there was another train that was closer to the crossing. At the same time, the grade crossing devices in this case weren't placed there by someone else. They were constructed by the defendants. So it's important to consider that when we're talking about the warnings that are being provided to someone in the position of Kelly Boyd.
May I ask you a procedural question that backs us up a little bit? The Sandler case, I think you're familiar with the Sandler case, recognizes in the footnote that there are two theories of recklessness in the restatement. It appears, at least the way I read that footnote, to say we follow only the first theory, thereby leaving it open for us to adopt the second theory. This case, I think Mr. Fleming stated when he was up here, was presented solely under the first theory. Am I right?
Don't think so.
I'm not sure that it got to
Well,
the
I guess
level
what
of
I'm
detail with
Well, what I'm leading to is if you lose in the trial court and on only one theory, and you don't make any argument about a new theory, then you're bound to lose up here because you've got to preserve your rights in the trial court for us to adopt a new theory. I didn't see anything in that appeals court opinion talking about that second theory. There's a citation to the Sandler case, but the definition they used was the first theory.
I think that's a fair reading of it.
Are you following me?
Yes.
And on the other
That's
hand,
not
you're
the
saying
theory.
it was all loose in the trial court, it was up for grabs, and which could open the door for the second theory to be adopted and applied to this case. Now, where that leads, I don't know. But
At the trial,
they're different theories.
they are.
One's subjective, one's objective.
Yes.
And the second one says if you violate a quota statute intentionally, that can be lead to finding of recklessness. Now here, there appears to be intentional, at least viewed from his point of view, violation of regulations, both on horn and speed.
I would argue that the evidence in this case does not support a finding of intentionality on the behalf of the actor, that it was mere inadvertence. And mere inadvertence is something that simply is
Has the
negligent.
plaintiff argued intentional as opposed to stating that? I mean, I don't know, for these purposes, if somebody's going over the speed limit, if somebody's not blowing a horn, I don't understand the difference between intentionality. If you put, I don't know how you accelerate a train, but in a car, if you put your foot further down on the accelerator, I don't know whether that's inadvertence or intentional, but either way, the question is not. The question, it seems to me, is for reckless persons whether you can take this to a jury.
Again, the key issue, respectfully, is a person in the position of the engineer in this case. What would they have? What did they know at the time that they were performing the acts or omissions?
They knew they had to sound a horn a quarter of a mile away from the intersection and didn't do it.
Yes.
They knew they had to keep to the speed limit and didn't do it.
But also,
they knew they were crossing, they were approaching a grade crossing. They knew they were going through a built-up area. They knew that, and so on and so forth.
sure, and also knew of the presence of an active warning system with lowered gates, ringing bells, flashing lights, the presence of another train that was proceeding in advance.
Again, Mr. Mitsu, no suggestion here that your client is liable. The question is, does this go to a jury?
The answer as to why it doesn't is, again, where knowledge of the risk is a component to recklessness. In the absence of any knowledge, whether subjectively or objectively, that they knew or should have known that Kelly Boyd was going to be on the tracks ahead.
Was there evidence of, or anything in the record on how many occasions kids were on, or people, or anything, were on these tracks when these grade crossings were? Was it frequent, infrequent, never? Once a month, twice a month? Any evidence of that?
There was evidence in the record that detailed as part of a safety evaluation project performed by the defendants as to circumstances where individuals were viewed circumventing the crossing systems. However, as a result of 23...
Did it show how many times?
Yes.
How many times was that?
I don't remember off the top of my head, because that evidence was deemed inadmissible for purposes of the summary judgment record. So for the court's consideration of this issue...
Why was it deemed inadmissible?
There's a federal statute, 23 U.S.C.
that bars it?
409, that bars that, because it was obtained as part of a construction project.
Can I ask a question, because maybe perhaps I didn't read this carefully enough, but was the evidence that the horn was never used approaching this crossing?
The evidence was that the horn was sounded somewhere between 3 and 5 seconds, or approximately 500 feet before the crossing.
Okay, and it was sounded for a very short period of time, I take it, then?
Somewhere between 3 to 5 seconds before the impact.
Okay.
And continued. It was a total of 5 seconds that the horn was sounded, presumably some shortly before impact and briefly after the impact.
And that's something that can be measured mechanically. I mean, that's not testimony. It was approximately 3, but that's literally the system will tell you how long the horn.
That's true. There is the equivalent of a black box from the plane.
And in terms of speed, is it clear that the engineer was aware of how fast he was going based on the speed gauge?
There's a disputed of fact as to precisely how fast the train was going. But for purposes of summary judgment, of course, we're assuming that the plaintiff's argument and the plaintiff's expert's evaluation of 92 miles an hour is true. There is a speed gauge in the cockpit of the train operator that you can see, how fast the train is going.
And what did that read? Is that something that the black box can tell us?
It does, and there's some evidence in the record with respect to the interpretation of the black box readings, which is why there's some dispute as to the precise speed as to whether the black box is accurate.
So viewing the light most favorable to the plaintiff, it's 92?
That's correct.
And what was it supposed to be?
80 under the federal guidelines.
Does the record indicate how long it would take to stop that train going at 80 miles an hour?
Well, the train did stop, I believe it was approximately 2,000 feet beyond the crossing. So that's as good an indication as any. The train engaged the emergency brakes either immediately before or at the time of impact, and the train continued on for approximately 2,000 feet. So to the extent that that is an indicator, which it should be, of the distance that it takes for a train to stop going at that speed, that would be in the record.
That was at 92. Is there any evidence about how long it takes to stop the train if it's going at 80?
Not specifically, no. And again, there's a dispute. Again, for purposes of this argument, we're assuming 92 miles an hour.
Right, no, we understand.
No, but I mean, it may be the train was going 92, but the gauge that the driver was seeing only said 80 or something. I don't know. Is that not an issue in this case, or is it?
Were this matter to proceed to trial, that would be an issue.
Okay.
Yes.
All right. Let me ask you one other question about. In spite of the fact that it was what the surveillance cameras were seeing as part of this safety study that's got federal rules protection, leaving that aside, was any of that information, for example, communicated to the drivers of the trains? That, we are picking up a fair number of people that are going around the grades, so just so you know.
Not that I'm aware of as part, and I don't believe the record reflects as part of this construction project. Engineers, as a matter of generally speaking, are certainly aware that people from time to time, whether it's at a grade crossing or at other stretches of track,
No, I understand that as a general matter. You assume that some people, for whatever reason, are going to look both ways and assume it's safe, and even though the lights are flashing, take cross, and we see that from time to time. But I was wondering whether the result of this sort of camera surveillance safety study, any of those have been communicated to the drivers to be on.
I don't believe that they had.
And your brother says that there weren't efforts made to educate students. Would you speak to that?
Sure. There's a program called Operation Lifesaver that is developed nationwide that the MBTA and Amtrak jointly implemented in this case, where there was materials that were distributed in the schools. There was on the public access cable programs, I believe some half-an-hour program that discussed the Operation Lifesaver program, and I believe that's reflected in the record. So,
And that was operative in this school system?
yes.
Okay.
The important, again, I want to emphasize that irrespective of how the evidence in this case is characterized with respect to recklessness, there simply is no evidence that the defendant's actions in this case caused the accident. And that's an important issue to consider, given I rest on my brief with respect to that issue.
Thank you, Mr. Measley.
Thank you.